welcome to tonight's event. My name is Uta Steiger. I direct the European Institute here at UCL, and it is my great pleasure to welcome you, if not to UCL physically, then at the very least to our virtual conference room. Tonight's event, which we are co-hosting with UCL's Faculty of Laws, will be all about the UK's 1998 Human Rights Act, the independent review of that act that took place between December 2020 and October 21, and also the government's proposals for its reform, which are currently out for public consultation. Yesterday evening, the last Lord Chancellor, Robert Buckland, spoke about his views on the implementation of the reform. But tonight at UCL, it is our even greater privilege to have with us the chair of the Independent Human Rights Act Review himself, Sir Peter Gross. Sir Peter and the event itself will be introduced and chaired by the most generous chair of the Institute's Advisory Board, Lord Anderson of Ipswich. David Anderson is a practicing barrister at Brooke Court Chambers and has some 200 appearances in the EU courts and the European Court of Human Rights under his belt. He has also served as the Council of Europe Human Rights Monitor and chairs the International Conflict Resolution Charity Intermediate. He also sits in Guernsey and Jersey as Justice of Appeal. As many of you will be aware, David also chaired the UK's independent review of terrorism legislation, and he was appointed, he was knighted for services to national security and civil liberties in 2018 and appointed to the House of Lords, where he now sits as a crossbench peer. And with that, David, thank you very much for coming and joining us tonight. So Peter, it's a pleasure. I hand over to you.
Thank you very much, Uta. Thank you to the European Institute and to the Faculty of Laws for hosting what I'm sure will be a very interesting and certainly a well-timed event. I'm going to very briefly introduce Sir Peter Gross, who was appointed by the then Lord Chancellor Robert Buckland to chair the Independent Human Rights Act Review in 2020. And by any measure, he was eminently qualified for the job. As a Lord Justice of Appeal, until he retired a few years ago, he served both as senior presiding judge for England and Wales and as lead judge for international relations. Anyone who has read the report of his review, which extends to more than 400 pages, will know just how thorough and impressive an exercise it is. So Peter is going to give us his reflections this evening, both on that review and, I hope, on the government's proposals for Human Rights Act reform. Without further ado, over to you, Sir Peter.
Lord Anderson, Dean of the Faculty, Dr. Steiger, colleagues, good evening. I am delighted to be here this evening and to deliver this lecture at the invitation of the UCL European Institute and the UCL Faculty of Laws. My thanks to Professor Steiger for organising the evening. Particular thanks to Lord Anderson for agreeing to chair the event. The structure of this lecture is straightforward. First, I shall focus on the work of the Independent Human Rights Act Review, IRA, which I had the pleasure and privilege to chair, and on its report, the IRA report, published on 14 December 2021. That report was accompanied by a short executive summary. Nothing I say should be taken as in any way amending either the report or the summary. I stand by both. Secondly, I shall suggest a categorization of the Ministry of Justice consultation paper, Human Rights Act Reform, a Modern Bill of Rights, a consultation to reform the Human Rights Act 1998, also published on the same day. The MOJ consultation paper, as I shall refer to it, so as properly to assess its relationship to the IRA report. As will be clear, my emphasis is on the substance of the IRA report, where a coherent package of practical recommendations is set out. I am concerned, as is the IRA panel, that those recommendations are carefully considered by Parliament when in due course it comes to debate HRA reform. IRA's position is and remains that those recommendations should be enacted in full, though that is, of course, Parliament's preserve. The substance of IRA's proposals should not be obscured in the crossfire surrounding the MOJ consultation paper. In December 2020, the then Lord Chancellor, the Right Honourable Robert Buckland, Queen's Counsel, established IRA to review the operation of the HRA, which had by then been in force for 20 years. Specifically, IRA was asked to consider two key themes. Theme one, the relationship between UK courts and the European Court of Human Rights, to which I shall refer as the Strasbourg Court. Theme two, the impact of the HRA on the relationship between the judiciary, the executive, that is government, and the legislature, that is the constitutional balance. The written ministerial statement called on IRA to consider these questions independently and thoroughly. It also stated that IRA's report, quote, will be published as will the government's response. As I have said before, it is necessary to grasp that the MOJ consultation paper is not a response to the IRA report. Contrast, please, the government's response to the report of the Independent Review of Administrative Law, IRAL. IRA had three features of paramount importance. First, it was an independent review. Secondly, its panel was independent and, if I may say so, formidable. Thirdly, its terms of reference were expressed in neutral terms, not suggesting preconceived or predetermined answers. There were none. I acknowledge here my debt of gratitude to all my panel colleagues for their outstanding work, with a level of engagement that could not have been taken for granted. Additionally, I record here my thanks to Dr. John Sarabji, IRA's principal legal advisor, for the excellence of his work, drafting and advice, going well beyond the call of any duty. As with any review, the terms of reference are crucial. It is necessary to underline both what was and was not within IRA's scope. First, IRA was informed by the government's commitment to the United Kingdom remaining a party to the European Convention on Human Rights, the Convention. This commitment served as a fixed premise for IRA and told in favour of a broad consistency of approach between UK courts and the Strasbourg Court. Secondly, an examination of substantive convention rights, let me be clear, fell outside IRA's scope. IRA's focus was on the operation of the HRA, the domestic statute. Thirdly, IRA was UK-wide and therefore concerned with England and Wales, Scotland and Northern Ireland. Throughout, the panel was very much alive to devolution issues and determined to take proper account of all parts of the United Kingdom. In the event, none of IRA's recommendations can sensibly be said to give rise to devolution concerns. I turn to our methodology. Throughout, IRA adopted an objective, evidence-based approach without preconceptions. It was emphatically not party political. From the outset, openness and transparency were hallmarks of IRA. I made that clear myself in some 38 conversations with interested parties at the time of IRA's launch. IRA's call for evidence encouraged responses from individuals and organizations wherever they might be on the spectrum of opinion. Upwards of 150 responses were received. Almost all were published on IRA's website, which is now a resource containing an exceptional store of knowledge and learning on the HRA. As travel around the United Kingdom was precluded by COVID, IRA held 13 online roundtables by way of smaller meetings involving targeted engagement with interested parties. One online roundtable with individuals who had personal experience of relying upon the HRA to give effect to their convention rights, and 7 online roadshows in lieu of town hall meetings, generously facilitated by universities around the UK, one of which was UCL. We also held a number of online meetings with judges of the Strasbourg Court, the German Constitutional Court, and the Irish Supreme Court. It is important to underline that IRA's recommendations were informed by the breadth, depth, and broad spectrum of this engagement, involving so many people across the United Kingdom and beyond, a factor worthy of consideration before departing from them. To ensure progress, the panel exercised self-discipline. Each panel meeting would produce a decision on the topic under discussion. We kept to that and concluded our work in good time. The panel ensured that there was room to accommodate dissent, as appears from both the report and the executive summary. Overall, IRA's conclusion was that the HRA had worked well, benefited many, and fulfilled 3 of its original objectives: bringing rights home, reducing the number of cases in which the United Kingdom loses in the Strasbourg Court, and facilitating a United Kingdom or British contribution to the development of Strasbourg jurisprudence, and the high regard in which our courts are rightly held by the Strasbourg Court, of which more below. As repeatedly emphasized to IRA, the working of the HRA was not to be viewed through the prism of a few high-profile cases. What happens outside the courtroom was of the first importance, especially with regard to the culture or mindset with which public authorities approach decision-making. The panel's work further revealed that there is clear room for a coherent package of practical reforms readily capable of implementation, with benefits both domestically and in the United Kingdom's relationship with Strasbourg. Domestically, IRA's proposed reforms seek to promote a settled acceptance of the HRA through a greater sense of public ownership of the rights in question. Majority support is needed through recognition that rights are for all. Consider, for example, the position of care homes in the pandemic. In formulating that package of reforms, we resisted the temptation to propose cosmetic changes, such as amending the reference to, quote, convention rights in section 1 of the HRA to read United Kingdom or British rights. Though mindful of the challenges, these considerations lead to IRA's first recommendation, much urged on it. Serious consideration should be given by government to developing an effective program of civic and constitutional education in schools, universities, and adult education. Such a program should particularly focus on questions about human rights, the balance to be struck between such rights and individual responsibilities. Section 2 of the HRA. I begin by disposing of a straw man. It has never been suggested, least of all by the Strasbourg Court, that Strasbourg Court decisions bind UK courts. They do not. Take into account in Section 2 HRA, patently does not mean bound by. IRA gave some thought to a declaratory amendment to Section 2 to say just that, but decided against it. As Strasbourg decisions do not form part of the hierarchy of UK court decisions, the rationale of Section 2 was to give guidance to UK courts as to how they were to be considered. Much thought has since been directed towards the relationship between Strasbourg case law and UK statute, common and case law. Inevitably, questions as to how closely UK courts might choose to adhere to Strasbourg jurisprudence have given rise to anxious consideration and adaptation over time, typical of a common law system. There are undoubted tensions in this context. First, a Strasbourg straitjacket on the development of UK jurisprudence was never intended. Secondly, mind the gap, if I may use that TfL phrase, a significant gap between rights protection before the UK courts and that available at the Strasbourg court would run counter to the United Kingdom's commitment to remaining a party to the convention and undermine the objective of bringing rights home. Thirdly, there will sometimes be good reason for a difference of view between United Kingdom courts and the Strasbourg court, and that is implicit in the important objective that United Kingdom courts will make a distinctive British or UK contribution to the development of Strasbourg case law. On occasions too, as the HRA makes clear, our courts will put the United Kingdom in breach of its international obligations, leaving the matter to be resolved at the political level. Fourthly, as the United Kingdom Supreme Court has emphasized, our courts are not to develop freestanding convention rights unsupported by Strasbourg case law. Fifthly, the injunction against developing freestanding convention rights does not apply to common law developments in accordance with the traditional common law method, guided throughout by the principle of judicial restraint and subject, as such developments always are, to parliamentary sovereignty. With these considerations in mind, IRA recommends amending Section 2 to clarify the priority of rights protection by making UK legislation, common law, and other case law the first port of call before, if then proceeding to interpret a convention right, Strasbourg case law is taken into account. This recommendation is straightforward and simple to implement. It gives the common law greater prominence, putting it center stage, reflecting its centuries-long protection of human rights. It codifies the approach taken by the Supreme Court in its decisions in Osborne and Kennedy. IRA's recommendation involves a natural approach, reflecting confidence in our own UK law as the starting point, an approach familiar to other convention states such as Ireland and Germany. It balances the various interests to which I have already referred and has domestic benefits through reinforcing the foundation for the HRA's settled acceptance. Likewise, it gives full and principled effect to the convention principle of subsidiarity. That is, that convention states, not the Strasbourg Court, have primary responsibility for human rights protection. A brief word on certain of the other options which the panel did not recommend. First, the panel received no detailed submissions on repeal and replacement of the HRA by a British Bill of Rights, which would, in any event, not have been within its terms of reference. To the contrary, there was overwhelming support for retaining the HRA. Secondly, although meriting careful thought, the panel did not recommend amending Section 2 to introduce a requirement to consider case law from other jurisdictions. Such an amendment would codify what the courts are already empowered to do. However, it might be seen as diluting the importance to be attached to Strasbourg jurisprudence, which would be curious given the United Kingdom commitment to remaining a party to the convention. In any event, it would introduce uncertainty as to the hierarchy to be accorded to other laws thus considered. Thirdly, while recognizing the attractions of the option, the majority of the panel were not persuaded to recommend statutory guidelines on the non-exhaustive circumstances to be taken into account when United Kingdom courts were considering whether to depart from Strasbourg case law. Such guidelines, even if non-exhaustive, risk fighting the last war. Moreover, if pitched at too high a level of generality, they would not provide useful guidance. Conversely, more specific guidance would result in an increased risk of satellite litigation. Sections 3 and 4. I start with the statutory architecture. The rationale for Section 3 is to avoid an undue gap between rights protection available from United Kingdom courts and from the Strasbourg court, which would undermine the objective of bringing rights home. The HRA constructed a careful balance between Sections 3 and 4, with declarations of incompatibility, Section 4, providing a last resort where interpretation in accordance with Section 3 was not possible. Clearly, Section 3 contains an unusual rule of interpretation, going beyond ordinary rules of interpretation and conferring a power and imposing a duty on UK courts to read and give effect to primary and secondary legislation so far as it is possible to do so in a way which is compatible with convention rights. The Section 3 rule is not conditional on any ambiguity in the legislation interpreted. Though a court giving effect to this rule is giving effect to the will of Parliament in enacting Section 3, a point, if I may say so, too often overlooked, concern as to this rule is readily understandable, creating, as it does, the danger of courts straying into territory more properly that of Parliament. Importantly, however, neither Section 3 nor Section 4 adversely affect parliamentary sovereignty. Sections 3 and 4 are clearly limited to a statutory review of legislation. Section 3, properly understood, confers an interpretative power within the well-settled province of the courts, not an amending power, the province of the legislature. There is no suggestion of either Section 3 or Section 4 encouraging common law review of the validity of primary legislation. With regard to Section 4, the court has a discretion to grant a declaration of incompatibility in keeping with the court's general discretion to grant declaratory relief. If the court makes a declaration of incompatibility, Parliament is not obliged to act on it. That is not to say that a declaration of incompatibility is other than an important signal of the court's view. It is to be expected that it will be carefully considered by Parliament, but Parliament has the last word. Making every allowance for the concerns as to Section 3, consideration of the evidence powerfully suggested diffusing such concerns through a focus on the facts as to the actual practice of the courts in deciding cases. The reality is that the high watermark of alarm as to the use of Section 3 hinges on a case now over 20 years old. The next most criticized decision dates back to 2004. Relatively settled, restraining guidance as to the use of Section 3 has stood for well over a decade. None of this suggested a pattern, still less an enduring pattern, of misuse of Section 3. Moreover, in a common law system, chasing and cherry-picking individual decisions where there is disagreement with the result is always unwise. It follows that statutory amendment to narrow the section itself risks uncertainty. Two additional features of Section 3 should be noted. First, in litigation involving government, ordinarily at least, government invites the court to use Section 3 rather than to default to Section 4. Secondly, perhaps strikingly, government has not sought to reverse decisions founded on Section 3, of which it disapproves. Overall, in the view of the majority of the panel, once the law had settled down post the HRA, the courts have been guided by judicial restraint and institutional respect. This majority conclusion is given effect and reflected in the options which follow. Notwithstanding the unusual rule of interpretation contained in Section 3, there was no substantive case for its repeal or amendment, or for altering the balance between Sections 3 and 4, leaving Section 4 as a rare last resort, or the standing requirements, that is locus standi, for either Section 3 or Section 4. Against this background, IRA's package of recommended options in connection with Section 3 focuses on shedding light rather than heat on the facts as to the actual practice of the courts. First, clarifying by way of amendment to Section 3 the order of priority in which United Kingdom courts apply the normal principles of interpretation and then the particular interpretative principle set out in Section 3. This amendment is simple to implement and is analogous to the amendment proposed in respect of Section 2. It is designed to assist clarity of analysis and contrast preconceptions with evidence and fact. Secondly, increase transparency in the use of Section 3 by the creation of a judgments database. By way of contrast, much more is known as to the use of Section 4 than is presently known as to the use of Section 3. Thirdly, an enhanced role for Parliament, in particular through the Joint Committee on Human Rights, the JCHR, in scrutinizing the Section 3 cases. Again, there is currently a contrast between the work done by the JCHR on Section 4 and that done on Section 3. To reiterate, IRA's package of recommended options should either allay concerns as to Section 3 or point the way to targeted statutory intervention. By contrast, any amendment diluting Section 3 at this stage risks a period of uncertainty and creating an undue gap between United Kingdom courts and Strasbourg. With regard to Section 4, a declaration of incompatibility is not a remedy, nor is it accepted to be an effective remedy by the Strasbourg court. An individual directly affected may therefore receive scant comfort from a declaration of incompatibility. IRA recommends the introduction of a discretionary ex gratia payment mechanism where a declaration of incompatibility is made. In practical terms, there is obvious attraction in such a mechanism being available domestically, thus reducing the time and cost of a matter of this nature needing to proceed to Strasbourg simply because of the absence of a domestic procedure. Judicial dialogue. For the majority of the panel, the question concerning judicial dialogue, formal and informal, between United Kingdom courts and the Strasbourg court yielded a straightforward answer. Such dialogue should continue to develop organically. The relationship between United Kingdom courts and the Strasbourg Court is and is intended to be interactive and dynamic. Dialogue is key to achieving this objective. Members of the panel met online with President Spano, together with Judges Ika and O'Leary of the Strasbourg Court in the course of IRA's consultations. At the time of the publication of the IRA report, I spoke again to President Spano and Judge Ika. IRA is most grateful to the Strasbourg Court for the time given and the constructive discussions which took place. As set out in the report, the Strasbourg Court has welcomed the mature equilibrium reached with United Kingdom courts. This neither means nor requires that UK courts and the Strasbourg Court always agree. It does entail mutual respect, bringing mutual benefit. Overall, IRA was struck by the high regard in which the United Kingdom courts and judiciary are held by the Strasbourg Court and the beneficial influence this has, both domestically and for Strasbourg. The use made by the Strasbourg Court in the Denmark case, to which the United Kingdom was not a party, in which the Strasbourg Court had regard to a judgment of a United Kingdom court interpreting a convention right, is but a striking example of this now mature relationship. Judicial dialogue will be a most important element in further developing that relationship and maintaining the equilibrium it has achieved. That dialogue between United Kingdom courts and the Strasbourg Court has borne fruit is beyond argument. Consider, by way of examples, Horncastle, the approach to hearsay evidence, McLaughlin or Hutchinson, the approach to whole life sentences, Rabone, where the Strasbourg Court reconsidered its own case law, so entailing a United Kingdom contribution to Strasbourg jurisprudence. IRA placed great store on strengthening and preserving that dialogue. It is important that the respect enjoyed by the United Kingdom courts and judiciary in Strasbourg and the Strasbourg Court's gratifying receptiveness to UK judicial thinking should be widely and better appreciated domestically. Such considerations are linked to questions of public awareness already discussed. This relationship is a UK asset undervalued domestically. Secondary legislation. Again, for the majority of the panel, the simple point here is that secondary legislation in the field of human rights is a subset of delegated legislation generally. It follows that IRA supports the IRAL proposal for the introduction of suspended quashing orders, both generally and in the particular context of designated derogation orders, where such orders are particularly appropriate. Notably, introducing suspended or prospective-only quashing orders mirrors existing legislation in Scotland, Wales, and Northern Ireland. And as with sections 3 and 4, IRA's concern was that the debate as to the court's approach to disapplying or quashing subordinate legislation in the human rights context exhibited more heat and less light than would be desirable. On the evidence presented to IRA overall, the courts had approached subordinate legislation with caution and respect for the differing institutional competences of government and the courts. Hence, here too, IRA recommended a judgments database to assist in establishing the facts as to the practice of the courts, and thus either diffuse concern or justify targeted remedial action. IRA considered, and rejected a proposal that the HRA should be amended to prevent subordinate legislation being quashed. Not the least of the objections to this proposal was that it would be curious if in the human rights sphere alone, delegated legislation could not be quashed on well-established judicial review grounds. One panel member argued that the research on subordinate legislation had focused on litigation and did not address a broader question of what was happening outside the courtroom. There it was suggested that the prospect of subordinate legislation being quashed for incompatibility with convention rights might have an adverse impact. For example, providing an impetus for overly cautious legislative drafting to minimize the prospect of politically motivated challenges to subordinate legislation. The majority of the panel were not unsympathetic to these concerns, but no evidence was presented to IHRA suggesting that effective policy making was being hindered in this way. Extraterritorial jurisdiction. The extraterritorial jurisdiction, what I call for shorthand ETJ, of the HRA is linked to that of the Convention. ETJ was one of the most significant topics considered by IHRA because of its potential impact on important UK interests. Additionally, because the extraterritorial and temporal scope of the HRA are sensitive areas for the relationship between the judiciary and government. In a nutshell, there is a problem to which the Strasbourg case law has given rise. In IHRA's view, the Convention was never intended to have a worldwide remit. Further, the Convention sits uneasily with international humanitarian law in times of active combat operations, where IHL, International Humanitarian Law, is the lex specialis. That problem, in IHRA's view, needs addressing. There is a clear case for change. The far more difficult question is how best to achieve such change. A unilateral solution, amending the HRA to restrict or remove its extraterritorial jurisdiction, tempting though it might be, would result in an own goal, potentially carrying very serious consequences for UK interests. The UK would remain a party to the Convention, so that our armed forces, agencies and police would be exposed to claims in Strasbourg without the prior consideration of UK courts and the assistance of, for example, closed material procedures. Moreover, in practical terms, UK armed forces, for instance, would still be operating on protocols geared to convention compliance. Accordingly, the solution needs to be multilateral at a convention level. IHRA's recommendations extend to a national conversation together with intergovernmental dialogue at convention level. Technically, there would be much to be said for an amending protocol to the convention, and it may be noted that there have been strong dissenting voices in Strasbourg as to the course taken by its jurisprudence in this area. So far as concerns institutional competence, addressing the problem of ETJ needs to be government-led. It can be augmented by judicial dialogue, but it cannot simply be left to the judiciary and the courts, nor can or should it go on hold indefinitely. Similar considerations apply to the fraught question of the Convention's temporal scope, where the Convention jurisprudence has troublingly built on the Article 2 procedural duty. Were there no limits to the HRA's retrospective temporal scope, it would make it necessary, in Lord Hoffman's graphic words, in principle, to investigate the deaths by state action of the princes in the Tower. Again, there is no easy answer by way of unilateral amendment to the HRA, which would create a damaging gap between domestic and Strasbourg remedies, here with potential devolution consequences. The temporal scope of the HRA is of particular concern in respect of Northern Ireland, but its application there falls outside the scope of the intergovernmental discussions recommended earlier. The MOJ consultation paper. Taking the IRA report as the starting point, the MOJ consultation paper can be broken down into the following categories. 1. Matters outside IRA's scope, such as deportation, freedom of expression and jury trial, the operational impact of judgments such as Osman, Ziegler and Cheshire West, proportionality. Those are matters which are and always were outside IRA's scope. 2. Matters where, with respect, it's not entirely clear what the MOJ consultation paper has in mind. Supremacy of the UK Supreme Court, particularly given Kay and Lambeth, discussed in the IRA report in Chapter 2. The other matter that might be mentioned here is the parliamentary democratic shield, not least given the continued principle of parliamentary sovereignty noted at numerous points within the IRA report. 3. Areas of apparent agreement, giving greater prominence to the common law in respect of Section 2 of the HRA. Not repealing Section 3 of the HRA, albeit the MOJ consultation paper focuses on proposed amendments to Section 3, in reality amounting to repeal. Exploring greater parliamentary involvement in respect of Section 3 judgments and a HRA judgment database. The introduction of suspended quashing orders. Remedial orders not being used to amend the HRA itself. The need for change in respect of the extraterritorial jurisdiction of the HRA, albeit change at the convention level, not unilateral change. 4th category, areas of apparent disagreement without addressing IRA's reasons for not recommending or rejecting those options. The removal of the provision from Section 2 requiring UK courts to take Strasbourg case law into account. The introduction of an express provision that UK courts may take other common law systems into account under Section 2. Amending Section 3 to limit its applicability to instances of legislative ambiguity only. Contemplating declarations of incompatibility as the only remedy available with regard to certain secondary legislation. The 5th category, areas which have not been addressed at all. IRA's comments on a Bill of Rights in Chapter 2 at paragraphs 13 and following. IRA's approach to the margin of appreciation and judicial restraint. Dialogue with the Strasbourg Court and the importance of the mature equilibrium reached between United Kingdom courts and the Strasbourg Court as a UK asset. The issue of the HRA's temporal jurisdiction, and finally, designated derogation orders. Concluding observations. As will be apparent, my focus has been on the substance of the IRA recommendations on their own merits. The government commissioned IRA, an independent panel, to review the workings of the HRA and to make recommendations for any improvement. The panel spent the best part of a year reviewing objectively the relevant case law and canvassing a vast array of opinions from academics, judges, practitioners, and the public around the UK and beyond. Our report concluded that the HRA is generally working well, but could work even better with a package of improvements proposed. The reaction of government has been to produce the MOJ consultation paper, which does not, with respect, respond to ours, is not grounded in anything approximating the exercise we conducted, but nevertheless asserts that the HRA is not working well. I have not taken up time in this lecture with a critique of the MOJ consultation paper. Cogent criticism has already been made of that paper by others, notably from UCL, including Professors Ormrod, Okeneja, and Hickman, Queen's Counsel, going to its selectivity, cherry-picking, contradictions, and risking uncertainty, together with an increased number of cases going to Strasbourg. Whatever view is taken of that criticism or other criticisms which feature in some of the responses to the consultation, IRA's position at the time of the report's publication was to urge government to implement its proposed reforms in full. That remains my position. Thank you very much.
Well, Peter, thank you very much indeed for that fascinating presentation.